Vital records are not citizenship. Why states must force a constitutional review on birth certificates issued through illegal alien status. There is a serious constitutional issue that states should no longer ignore. When a state issues a birth certificate to a child born from parents who are illegal aliens, is that state simply recording a birth event? Or is that record being used as a backdoor citizenship instrument? A birth certificate is a state vital record. It records that a birth happened within a state's borders. The CDC directs people seeking birth records to the state or territory where the birth occurred, showing that vital records are maintained through state systems, not one single federal birth registry. But citizenship is not supposed to be created by paperwork alone. The 14th Amendment says that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. Federal law also recognizes citizenship at birth for a person born in the United States and subject to its jurisdiction. That means the constitutional question has two parts: birth location and jurisdiction. This is where the illegal alien question must be raised. If the parents had no lawful national status, no lawful immigration standing, and entered or remained in the country outside the law, should a state-issued birth record automatically become the paper pathway into citizenship recognition? Or should there be a constitutional review before that state vital record is treated as citizenship evidence? This is why states have a legitimate reason to question whether a state vital record should automatically become citizenship evidence without deeper review. The U.S. Department of State currently lists a qualifying U.S. birth certificate as primary evidence of U.S. citizenship for passport purposes, but that proves the problem. A state record can later become the gateway into federal citizenship recognition. This does not violate the 14th Amendment. The state is not denying that a birth happened. The state is saying that a birth record connected to illegal alien status should not automatically override the constitutional question of jurisdiction, lawful status, allegiance, and national standing. A birth certificate records an event. The Constitution determines citizenship. Those two things should not be collapsed into one automatic process. If a state refuses to allow its vital record system to be used as a backdoor citizenship pathway through illegal alien status, then let the lawsuit come. Let the issue go all the way up. Let the Supreme Court answer the real question. Does a state have the right to control how its vital records are issued, verified, honored, and relied upon? Or can federal policy force states to produce documents that later operate as citizenship evidence? This is why genealogy is important. Genealogy is not just family history. Genealogy is proof of identity, parentage, status, record continuity, community attachment, and lawful standing. It is how people prove who they are, where they come from, and what legal or historical status they are connected to. Freedmen understand this better than anyone. Freedmen had the 14th Amendment on paper, yet were still forced through Jim Crow, misclassification, denial of equal protection, and government systems that failed to enforce the very rights the Constitution promised. Paper alone did not protect freedmen. Records had to be proven. Status had to be enforced. Identity had to be defended. So if government systems require freedmen to prove genealogy, census anchors, birth connections, family lines, and legal status, then government records should also be examined carefully when those same records are being used to claim citizenship, benefits, passports, and constitutional standing through illegal alien status. The issue is not whether a child was born. The issue is whether a state birth certificate issued from an illegal alien birth circumstance should automatically become citizenship proof without constitutional review. That does not attack the 14th Amendment. It takes the 14th Amendment seriously. States should test this. States should challenge this. States should force the courts to clarify whether vital records are merely records, or whether they have been quietly turned into citizenship instruments without the people ever receiving a real constitutional answer. The Constitution should control the document. The document should not control the Constitution. Support the work. Donate through Cash App, Freedmen Legal Fund. Visit Freedmen Nation.